Begin transmission. The titular Queen of Australia, and the Act of Treason. A simple explanation of how and why the office of Queen of Australia cannot exist at law. In a 1988 Constitutional Commission report, it was also confirmed the Queen of Australia was not for law-making purposes. They had no lawful means of creating a new authority, so instead they ended up with a titular authority. Define titular, adjective. Holding or constituting a purely formal position or title without any real authority. Every member and senator has committed an act of treason by swearing and subscribing to an oath to serve the Queen of Australia, foreign to the Commonwealth of Australia and its supreme law. To confirm this, the Commonwealth Constitution at Section 42 dictates that they must all swear and subscribe an oath of allegiance to the current monarch in the sovereignty of the United Kingdom. Clearly this constitutes an act of treason against the sovereign people of the Commonwealth of Australia. The oath appears as the schedule to the Commonwealth Constitution Act, and is outside of the actual Constitution, S1 to S128, and is beyond the reach of Section 128. And cannot be altered by any authority outside of the UK Parliament. The people only have the right to change Sections 1 to 128 of Clause 9 of the Act, with the government being left with no right or authority to change anything whatsoever. The Queen of Australia is purely titular. If such an office exists at all, it does so without any lawful authority. Since the Bill of Rights of 1688, the Act of Settlement of 1701, and the Act of Union 1706, the monarch has been appointed by the English UK Parliament, and not by the Parliament of the Commonwealth of Australia or its de facto known as the Australian Parliament. In 1973, Queen Elizabeth II amused Gough Whitlam by acknowledging the Royal Styles and Titles Act of 1973, which repealed the Royal Styles and Titles Act of 1953, and created the statutory instrument Queen of Australia. Such an office does not exist in UK law, or more importantly, under the Commonwealth of Australia Constitution Act 1900, UK. The Commonwealth of Australia Constitution Act is UK law and by definition Clause 2 of the Act, the only monarch that the Constitution, Clause 9 of the Act, recognizes as the Queen of the United Kingdom. Any law made under the Constitution cannot be given valid royal assent by a Governor-General, or Governor, appointed by and representing the de facto Queen of Australia period. Even if it were possible to alter the Commonwealth Constitution so that it recognizes the Queen of Australia, a referendum under S128 relating to the adoption of such an office would be necessary. Such a referendum has never been conducted, but as already stated, Clause 1 to 8 and the schedule itself, is simply beyond the people's authority to change. Attempts to patch up the constitutional mess continued by the concealment of the truth from the people by passing the Australia Acts, CTH and UK, through both the UK Parliament and the Parliament of the Commonwealth of Australia in 1985 to commence in 1986. Both of these acts are an attempt to infringe the sovereignty of the people of the Commonwealth of Australia, but have no lawful or constitutional validity. Some see the Australia Acts as a replacement constitution. This is simply false. The Australia Acts were a cover-up for the mess Gough Whitlam had created in 1973, and the Queen knew it and only acknowledged the Australia Acts, UK and CTH, by signing the top of the page. End transmission.